When most people think about estate planning, they think about, well, we're talking about my will or perhaps a trust. What happens when I die? And that is where a person's estate planning documents will start to look different depending on what their situation is. So, for example, if somebody has a lot of property, they have a taxable estate, which in Washington, a taxable estate is $2.193 million, then their will or their trust might look different than someone who has no home, very modest means. But yet, even though the document and what's in the document might look different, everyone does also need to have either a will or a trust. What these documents do is on your death, they pass assets to whomever you want to receive the assets. Let's talk about a will. Let's talk about a trust. Let's talk about how they are different. Now, a lot of financial advisors say that everybody needs a revocable living trust. And a lot of those financial advisors are in states other than Washington state. In Washington state, we have a very simple probate process. It is not a probate that is complicated. It is not, fees associated with probate aren't dependent upon what the value of the estate is. It's dependent upon how much work is involved. Other states are different. California, for example, their probate process is very complicated, costly. And in that state, for example, a revocable living trust might be the best way to go for the majority of people. So this is when I want to remind you that I am Washington-centric in the discussion today. So what is a revocable living trust? That is a legal document that you sign while you are alive. And if you are creating the revocable living trust, you are the grantor, which means, and the trustor, which means you're the person who's creating the document. You are likely the trustee. That means you are the person in charge of managing the trust assets. And if you're married, perhaps you and your spouse are both trustees, you're co-trustees. You're likely also the beneficiary of the trust, as your spouse may be if you're married. Beneficiary means you get all the benefits of all the assets in the trust. And then the trust likely will say where the assets go when you pass away. If you pass first and you're married, your spouse will likely be the person who now is the beneficiary of this trust. And when your spouse dies, then it typically says that the trust assets go wherever you want them to go, which may be to your children, for example, or wherever you want them to go. Revocable living trusts are often misunderstood because with a revocable living trust, you still feel like you own the assets, you're in charge of the assets, you benefit from the assets, and you don't even need to file a tax return because there is no separate tax entity. So with a revocable living trust, one of the problems with them is that once they're set up and perhaps initially funded, after that, they're ignored. And if they are ignored, that's when the problems occur. A revocable living trust is intended to manage the property while you're alive and then distribute it on your death. If the property is not titled in the name of the trust, then the trust does not control it. So, for example, you maybe put your house into the trust with the help of the attorney, and you did a deed to put the house in the trust. So it's titled not in your name, but in your name as trustee of a trust. So the trust is funded now with your house. But what happens if you decide that you want to open up a new bank account and you forget that you're supposed to open up that new bank account in your name as trustee of the trust? If that happens, and it happens quite commonly, then the trust does not control that bank account. So when you pass away, the trust has no control over any assets that are outside of the trust. As a result, and it's very common, what occurs is people will have a probate after their death plus a trust administration. So the whole goal of having the revocable living trust was to avoid probate, but because the trusts are not well understood, or maybe the person didn't seek ongoing legal help to remind them how does the trust work when they die, not only is there the trust administration, but a probate. If you have a revocable living trust, you'll know that you have what's called a pour-over will. Why do you have a pour-over will? Because so commonly assets are outside the trust that there needs to be a will to capture those through a probate, bring them back into the trust so that they can be distributed. I'm not saying that trusts aren't a great idea, revocable living trusts. They certainly can be. It depends on what your situation is. There's no rule that says, yes, you must have a trust, or no, you must not have a trust. What I'm trying to emphasize is that whether or not a revocable living trust is right for you depends on your particular situation. And please don't rely on a financial advisor. See an attorney to find out whether your situation is right for a revocable living trust. And if you do have a revocable living trust as your platform for the estate plan, make sure that you understand it so that it can be operated correctly.